Hi, my name is DiResta. It's a delight to welcome you to our event on the culture war, FTC investigations, and the First Amendment. I'm a professor here at Georgetown Law School. It's my delight to collaborate with Tech Institute and with TechFreedom to hold this mini symposium today. So during the Biden administration, it was the political opposition that claimed that the FTC had politicized its operations, using its power to demand that internet platforms push the Biden administration's agenda. When Elon Musk took over Twitter, he began releasing internal communications with the federal government in what came to be known as the Twitter files. Independent reports dispute the claims of a censorship industrial complex, but it has become canonical in certain political circles. So it may come as a surprise, perhaps not, that the roles are now reversed. The political opposition now is claiming that the FTC, under a new administration, the Trump administration, is using its tools to put the current administration's political agenda. So we'll host two public panels today to discuss these issues. We've assembled many of the participants in these current events, and thanks especially to Berin Szóka for finding these incredible speakers. The first panel will be moderated by my Georgetown colleague, Renee DiResta. Renee is the Associate Research Professor at Georgetown McCourt's School of Public Policy. She is the author of Invisible Rulers, The People Who Turn Lies into Reality, published by Public Affairs. Her panel will lay out what is going on today. The second panel, occurring in the second hour, between 1 and 2 roughly, will be moderated by Bilal Syed of TechFreedom. Bilal was himself once the director of the FTC's Office of Policy Planning during some of this controversial period. His panel will focus on the legal issues presented. The event would not have been possible without the tremendous leadership of Berin Szóka of TechFreedom, as well as Tech Institute's Natalie Roisman and Margot Williams. I also want to single out two other folks at TechFreedom, Dan Benvente, who has helped do all the finances and the grant that made all of this possible, and Jared, who is helping run all the technology in this room. And of course, Kyle in the back, our Georgetown Law Tech person who's been helping me for many, many years. So thank you. Many of you already grabbed lunch. Please feel free to grab lunch. And also there's dessert on this side, drinks and dessert. The cobbler looks really good. I'm definitely gonna have some. So please join me in welcoming Renee DiResta and her panel.
I think we've got some virtual folks, and we're going to start with Olivia. Thank you all for being with us today.
Well, good. Is that pressure, or is that sort of unacceptable pressure in your view for the government to say to these independent institutions, we want you to do that? Or is there something else going on?
So I think it depends on sort of whose version you believe. I don't know if you read the district court opinion. The district court's view was this wasn't just, hey, do us a solid or do the country a solid. Mm-hmm. It was like, do it or else.
Yeah, what is the or else? That's what I didn't get. Like, the threat, the implicit threat, however you saw it.
I think it's the same threat that a government can always potentially inflict on any marketplace participant, which is we can make your life difficult. The regulators can show up, they can audit, they can investigate, they can cost you a lot of money. And the path of least resistance is do what we say. I mean, this is not dissimilar to the issue the Supreme Court confronted with the New York financial regulators, calling up people and saying, quit doing business with the NRA or else. And the or else is just, we have a tremendous array of investigative tools. Those tools are expensive when applied to you, even if we don't win at the end of the day. So knuckle under. And, the court's conclusion for state action purposes was it wasn't sufficient to transform the social media companies into arms of the state. I just don't think it.
Right. So this panel is about whether the FTC is using very agency tools for extraordinary ideological purposes. So we'll be talking about public inquiries, warning letters, merger conditions, civil investigative demands aimed at private companies and nonprofits that have been involved in content moderation, brand safety, and topics that the administration finds distasteful. So yes, so for those who don't know, that was Andrew Ferguson sitting up there being interviewed, and Ferguson's pre-chair pitch explicitly centered on sort of fighting wokeness, stopping big tech censorship, and investigating advertiser boycotts. And the current agency's actions track those buckets closely. So I guess we'll start by having our panelists introduce themselves and talk a little bit about their first-hand experience with the topic. I'm Renee DiResta, as my colleague mentioned, and in certain parts of the world, I run the censorship industrial complex. So, I'm very well qualified to moderate this panel.
My name is Vanessa Otero. I'm the founder and CEO of Ad Fontes Media. We're best known for an infographic called the Media Bias Chart, and we rate news content for reliability and political bias. And related to this, we are the recipient of a civil investigative demand from the FTC, and a number of others were recipients of those as well. Not just companies like ours in the space of rating news and content and misinformation, but also other folks in the broader brand safety advertising ecosystem and related industry organizations. So happy to talk about that.
Gordon, let's go to you.
Thank you, Renee and Vanessa. Nice to see you. So let me start with a little bit of disclosure, which is my own political views. I've been a libertarian-leaning conservative all my adult life. I wrote for the opinion pages of the Wall Street Journal for many years. Berin was a great source of mine. I believe in free markets and limited government, and I never thought that a Republican chairman of a regulatory agency would instead meddle in markets and claim the regulatory powers that are so broad that they include violating the First Amendment and censoring my free speech rights. So we're a recipient of the CID, as Vanessa's company is. We also were the target of a consent order in the largest merger of ad agencies. And we decided not to be passive recipients of First Amendment violations. We've brought a case, NewsGuard v. FTC, which is our story of trying to enforce our First Amendment rights. You'll hear later from our lawyer at Fire, Bob Corn-Revere. But let me just touch on a little bit of what NewsGuard does and why we develop some opponents, particularly a website called Newsmax that gets a low trust rating from NewsGuard. So NewsGuard was founded in 2018. We rate news sites based on apolitical criteria. We publish detailed analyses of those websites. We give sites a trust score from 0 to 100. As Vanessa mentioned, advertisers use services like ours and hers because of the nature of programmatic advertising. The average ad these days appears on more than 40,000 websites. As a result, CEOs and CMOs have no idea where their ads are ending up. One year, we discovered that Warren Buffett was the biggest advertiser on Russian disinformation sites because his Geico insurance company was a big advertiser on Sputnik News. He didn't intend to subsidize Vladimir Putin, but he is CEO of Geico, the CMO of Geico. The agency had no idea where the ads were ending up. One little bit of legal background. This is not our first run-in with a legal claim. A far-left website called Consortium News sued us a few years ago claiming that our rating was defamation, was defamatory. That case was dismissed by a federal district court judge with prejudice, who pointed out that we had as much right to rate news websites as restaurant reviewers have of rating restaurants. Some conservative websites have also opposed their rating. Newsmax, in particular, has been highly active as a lobbyist at the state level, lobbying members of Congress, lobbying the chairman of the FCC. and most definitely lobbying the FTC, as we'll talk about. Newsmax is offended because it gets a much lower score from NewsGuard than does Fox News, its main competitor for advertising. You can read our ratings for Newsmax. We think they deserve their low trust scores, but the claim that we're biased against is wrong and, to me, quite insulting. As examples, the Daily Caller gets a better score from us than the Daily Beast. The Daily Wire outscores the Daily Cause. Fox News outscores MSNBC. So we'll talk, I think, about whether Andrew Ferguson, in his interview that you saw there with Eric Posner at UChicago Law School, whether he was laying out his own strategy. That is certainly how it seems to us. You heard him say that FTC tools are expensive when applied to you, even if we don't win at the end of the day, so knuckle under. We're not knuckling under. And we're fighting the CID in NewsGuard v. FTC. We're also fighting the consent order that's demanded of Omnicom when it merged with IPG. These are the two of the biggest ad agencies, $13 billion merger. It had only two conditions. One was no more DEI, which I think is a standard provision. The other one was that the Omnicom could not work with any rating service that rated on the basis of political viewpoint. That was the first draft of the consent order. We saw that and said, oh, bullet dodged. We don't do that. We don't consider political point of view when we do our ratings. Newsmax also noticed, and Newsmax filed during the public comment period a 14-page single-spaced objection saying that the consent order as written wouldn't apply to NewsGuard because we don't rate on the basis of politics. The FTC complied with that lobbying. The final order says that the biggest ad agency in the United States is prohibited from using any service that evaluates, quote, the veracity of news or, quote, journalistic standards. How is Warren Buffett going to keep his ads off Sputnik News? So this, to us, goes way beyond jawboning. This is forcing an ad agency to put us on a blacklist. We're losing clients among ad agencies because of it, which we think is the FTC intent. We filed suit seeking injunctive relief as regards both the CID and the consent order to the degree that it applies. And I'll have more to say about it, but I did want to give that background and to be sure that you're aware not only of the CID issue, abusive enough, but of this terrifically abusive consent order where the government has put itself in the position of telling the world's largest ad agency that it can't rely on the ratings of a private company in order to help its clients avoid supporting Russian disinformation.
I think we're gonna go into that also because I think we just saw you shouldn't case them down with regard to Elon Musk. So hold that thought for a second. Josh, let's bring you in here for a second and hear about Law's experience in the realm of FTC and Brazil.
Yeah, for sure. First, thank you for having me, and thanks to TechFreedom and Georgetown and others for organizing this. It's really timely and important conversation to be having. So I'm Josh Rovenger. I'm the legal director at Glad Law. We are an LGBTQ civil rights organization that uses all aspects of the law to advance equality for LGBTQ individuals. Over the past several years, that has meant doing extensive work fighting back against government regulations and efforts to attack transgender individuals' access to healthcare, and in particular, transgender adolescents' access to healthcare. So, thus far, we've brought 9 actions against the current administration, and several do relate to its ongoing campaign against transgender healthcare, including one against the Department of Defense for denying coverage for adults, and another in the DOJ subpoena context on behalf of families who sought and obtained care at Children's National Hospital, who we were able to successfully quash a subpoena of their private information. So the FTC CIDs in the trans healthcare front, which I know we'll talk about in more detail later, is just kind of one of a number of fronts in this space. And we are working really closely with partner organizations to help navigate the CIDs that have already been issued to the 3 medical associations that we'll talk about, and are also doing a lot of work to gear up for potential expansion of FTC investigations in this space. I'm looking forward to talking about all of that in more depth.
I think also I'll mention that in February 2025, the FTC launched a public inquiry asking for information about how platform moderation might itself be collusive behavior and how it might deny or degrade access to users based on speech or affiliation. So it's another bucket of investigations. There's an RFI public inquiry there. So we've had a lot of different ways in which we've seen the FTC act. Let's go into, I think, one of the things that's been very interesting in the way that these cases have played out or the way that these investigations have been executed is that the cost is extraordinary. And we have seen, I'll mention the Elon Musk case in this context. So the World Federation of Advertisers and a nonprofit, a Global Alliance for Responsible Media that also involved themselves many thinking through where advertisers should or should not put their ad dollars. And Jim Jordan subpoenaed that entity. That was a congressional investigation. And as that process was going on, different entities got involved. I believe the Attorney General of Texas, if I'm not mistaken, launched an investigation there as well. Elon Musk sued. He just lost that case. That was just dismissed with prejudice, I believe. And however, in the 2.5 years that took to happen, the nonprofit was dissolved, and WFA said, this costs too much money, to actually fight this. And so they actually sent it back, and we had to comply with with beginning to advertise again and to sort of do the things that the case had sought to essentially compel them to do. So what we see over and over again is losses in court. This happened in my situation as well. Losses in court that nonetheless lead to the dissolution of the entities because the cost to comply, the cost to fight is so expensive. So I'm curious to hear, maybe Vanessa, let's start with you. What does this process cost for you in terms of time, legal expense, staff attention, business uncertainty, as you move through this investigative process?
Well, we first received the FTC CID in May of last year, so it's been about 10 months. And before I started my company, I launched the company in 2018, but I was actually practicing as a patent attorney. I was a lawyer for about 6 years in total, and it was mostly, patent prosecution, nothing to do with any of this stuff. But occasionally I would help out on discovery, like arbitration, things like that. So as an associate, whenever I saw a document discovery, like a subpoena, a discovery request, I would think, oh, that's a lot of billable hours. Receiving such a thing as a CEO, I was like, oh, so many billable hours. Because it was so extensive. I mean, the CID literally asks for every document that we've ever created, all financial records since 2018, everything ever produced for financial records. Why? That's not sure. All product information, all sales decks, all employees, current and former org charts, all communications with a list of 17 different entities. All communications are related to anything having to do with rating news content. Everything about our methodology, our process, our training. So really, truly, every document we'd ever created. And the CID is supposed to state on its face with some specificity the nature of what's being investigated, because as many of you know, when a CID is issued by a government organization, you don't even have to be charged with something. You don't even have to be the target of the investigation. But the DOJ and SEC and various other federal agencies have this pretty broad investigative tool. I had not seen a CID when I was in practice. That was really odd. So it came across to me like, well, don't they have some sort of barrier of entry? Like, can they really ask for all these things? And the statutes give the agencies some pretty broad power, but it's supposed to be limited in scope to a thing that they're actually pursuing. So it mentioned something obliquely about collusion. Just trying to rack my brain on what collusion could possibly be. And I knew what it was related to. I knew it was related to all these cases. I was very familiar with GARM and the expense that had wrought on the expense and time and, anguish that it caused to the people involved. I mean, a lot of the companies that are involved in this are small. There are nonprofits involved. There were the recipients of CIDs. I had seen GARM was run by a couple of people. Rob Rakowitz was the leader of GARM, and as the head of this organization, it being subject to these House Judiciary Committee inquiries. The attacks in the press and the personal threats and messages he got on social media. I mean, imagine the New York Post running a headline that says, fascist creep Rob Rakowitz wants to control what you read. Like that was the kind of press attention that he was getting as a private individual running a industry nonprofit. So when we saw the CID, what it seemed like to me was like, yes, not only the cost, but what kind of other political pressure we have our entire existence prided ourselves on being nonpartisan, cross-partisan, very collaborative to mitigate our own bias. Like no organization is free from bias, but making sure that we have a rigorous defensible methodology is super important to us. We didn't think that was going to save us from political attacks, and it kind of never does these days. So it's expensive. It's a little threatening, chilling to our employees. Our employees are like, well, we've been doing a good job, but should we not email stuff? What should we do? It's natural for any organization, I think. We're at the stage where we've produced a lot of documents, and for now, it seems the FTC, probably because other organizations like Media Matters, GDI, and NewsGuard have sued. Hopefully they are pumping the brakes, but we don't know. I mean, these cases are obviously still pending. So there's the enormous legal costs, but then the chilling of the speech of others in the industry. Their advertising agencies are notoriously apolitical. They try to reach all customers, brands. Most brands try to be apolitical. Doesn't work. You can't be apolitical these days about anything. But they try not to get in the crosshairs of the government. So we know for sure that this has caused ad agencies to refrain from doing business with us. They have told us this. Not just, and it's not the Omnicom and IPG, which are two of the largest ad agencies now combined into one. That's one segment. But think about the effect on the other holding companies, on the other ad agencies who also want to prevent this from raining down on their heads. They're very, very quiet about what they say. They don't talk about it on LinkedIn. People love talking about stuff on LinkedIn. People have to, they really have to limit themselves. And I think that's the primary harm. It's the speech harm. It's a chilling of speech harm.
Gordon, I know you had mentioned, I think, in your petition that compliance costs had already exceeded 28% of the revenue from relevant brand safety services, if I'm not mistaken. I'm curious, both sort of your perspective here, as you have chosen to fight back, right, to file to whatever extent you can comment on that. I know it's pending litigation, but also how should people think about the difference between brand safety tools that inform advertiser choice and then actual coordination? How should the public understand that difference?
Sorry, the difference, Renee, between
brand safety tools that inform advertiser choice and then what they're sort of accusing you of actual coordination among firms.
Sure. So let me start with the latter, and then I'll add a bit to Vanessa's excellent summary of the effect of a CID. So over the last decade or so, programmatic advertising has really taken over advertising. When I was publisher of the Wall Street Journal, I go and call on advertisers and I would say, wouldn't you like to advertise in the Journal instead of the Times or instead of Business Week or instead of Fortune? And we kind of battled it out for market share in that way. That's not how it works anymore. The way it works now is an advertiser will say, I want to reach this kind of person with this kind of psychographic and demographic. As a result of that, ads end up on those more than 40,000 websites. Many of the sources of misinformation that we all read about are in the business of generating revenue from advertising. The social media platforms, Renee, as you know better than I do, publishing misinformation for them was not a bug. That is a feature. It generates eyeballs, it generates engagement, it generates ad revenue. And it generates ad revenue because the brands don't have adequate tools to be able to keep their ads away from sites or platforms that they don't like. We'll talk later, I think, about the X's case against the World Federation of Advertisers and about a half dozen blue chip.
Gordon, can you speak up just a little bit?
Sure. We'll talk about the decision against X in a moment. But let me turn to the other part of your question, Renee, which is the cost. So, when you get a CID, we had a very similar reaction to Vanessa's. What is this? What's this going to cost us? We engaged with our Washington law firm. They explained the way you negotiate with a regulatory agency over a CID. It's back and forth. And usually within a half dozen meetings, you end up with them really winnowing down what it is that they're looking for. And we said, well, they better do that because they're asking for all of our reporters' notes. They're asking for the names and identification of all of our subscribers. We know from a long line of cases that is unconstitutional. We're certainly not going to give that up. And over the course of 10 meetings, I think it was back and forth, we produced more than 40,000 pages of documents. We didn't give up anything that was protected by the First Amendment, but we complied. We gave them the benefit of presumption of regularity, I guess, as the lawyers put it. But after about 10 of those meetings, we thought we were close, and then they backtracked. And they said, no, you got to give us, almost everything that we asked for before. That process, which took months, cost us now, Renee, the dollar amount is even more. It was 30% of all of our revenues from serving the advertising market. So not 30% of our profits, 30% of our revenues. That was the cost. And since then, it's had the effect that Vanessa described, which is the ad agencies are terrified because of what Omnicom was coerced into agreeing to with that consent order, which is not using services to protect its clients. Many of them have gone quiet. We've lost other contracts because of it. This is, we believe, the political intent and the political justification for bringing a lawsuit that so clearly violates the First Amendment. They're getting the impact that they want without necessarily caring that much about winning in court, or at least that's how I would interpret the weak case that they have. By the way, part of the CID process is that the FTC gets to grade its own homework. When you bring a motion to quash a CID, we learned, that's not in federal district court, as you might think it would be. It's up to the FTC. Surprise, surprise, the FTC ruled against us in our motion to quash. It was another reason why we decided to become a plaintiff, a position I never thought I'd be in, a plaintiff in federal district court to try to remedy an absurd situation where an independent regulatory agency, no political accountability, is able to rule whether it behaved responsibly. It's an absurd system, and I certainly hope that the federal courts take care of this abuse as it has other abuses.
I'll say, Moderator Scargate, that we were also asked to turn over to Jake Gordon and the Weaponization Committee. 5 years worth of emails, every email we ever sent to any tech company or any entity within the United States government as evidence that we had colluded with the Biden censorship regime, even though we were working with Trump administration officials. And then the materials that we turned over under subpoena on their way to America First Legal, which was plaintiff's counsel in the litigation that they sued us in Louisiana. So it is incredible to watch that in action. Josh, let me bring you back in because the gender care cases are not about media ratings or advertising tools, but they do raise a similar question about whether the agency is using consumer protection authority to target speech it dislikes. What's pretty similar about the posture there and what is different?
Yeah, for sure. So I think there are a few things that may differentiate what's happening here, which I'll just kind of broaden out the conversation a little bit, which is to give a little context on where the FTC's attacks on these medical associations are even coming from. So pretty immediately, the administration came in and launched a multi-agency campaign to target transgender healthcare, particularly for adolescents. That included various executive orders, various agency policies, DOJ subpoenas targeting 20 plus doctors, clinics, and hospitals, demanding sweeping patient data, and then rulemaking through HHS seeking to condition all Medicare and Medicaid funding on an institution's refusal to provide this care. So the FTC attacks in this context arises within the context of an administration that has not hidden its distaste for transgender healthcare and more broadly transgender individuals. And it started last summer where in what it titled a listening workshop, the FTC held a workshop called The Dangers of Gender Affirming Care for Minors, and really kind of gave away the game during that workshop. Throughout it, there were folks who talked about how the FTC's authority could be implicated if there was evidence that medical professionals or others omitted warnings about the risks or made false or unsupported claims about the benefits and effectiveness of trans healthcare. It really became clear from that workshop that the FTC was starting to develop a theory that consumers were being harmed by exposure to quote unquote false or unsupported claims about gender affirming care, and that those claims could be leveraged against medical associations. And so what we then saw this January was the FTC to issue 3 different CIDs, one against the American Academy of Pediatrics, and that one relates to a policy statement that synthesizes scientific research on trans healthcare, a CID to the World Professional Association for Transgender Health, or WPATH, which targets its standards of care guidance that it's been issuing since the 70s and have been really the gold standard since the 70s. And then a third to the Endocrine Society, targeting its clinical practice guidelines related to hormone therapy, and a 2020 position statement on transgender health. And, what really makes these investigations pernicious is it's targeting these professional medical organizations for what they're saying. Their published clinical guidance, their position statements, and ultimately, for some of them, their scientific recommendations. And I think like the CIDs that we've talked about, they are also just extraordinarily broad and sweeping CIDs, including production of all communications with doctors and other professional medical either associations or individuals that's in any way related to transgender healthcare. So it's this extremely broad scope that also imposes a continuing obligation on all of these entities until the FTC determines that its investigation ends. And it comes, on the heels of this kind of multifaceted campaign from the administration on trans healthcare specifically and trans rights more generally.
How should we think about, as Gordon's case progresses and others progress, FTC, if it wins, if it loses, what has it already accomplished?
Well, it has cost us clients. It clearly cost us Omnicom as a client because they were coerced into signing a consent order promising not to use us. I think it's also established a very dangerous precedent, which is that a government agency, whether through a consent order or through abuse of CIDs, can violate the First Amendment indirectly. I say indirectly because people don't think at first of a subpoena as a violation of the First Amendment. They don't necessarily think of a consent order in an advertising agency merger. That doesn't sound like a First Amendment issue at all. But these are First Amendment issues. These are retaliatory actions by a federal agency seeking, on the basis of content discrimination, to censor the work of groups like NewsGuard and Advantis and others. That's what this is about. So,
I think,
yeah.
but
So, we did file suit in federal court because we were persuaded that the First Amendment is not just a right, but also in a way an obligation. We're spending a lot of time and effort on it. We do have pro bono lawyers for which we are absolutely grateful. And without pro bono lawyers, probably we couldn't frame a case like this.
I think what's so striking about this is that it's the FTC that's going after us. I mean, this is an agency that's charged with regulating commercial laws. And what is it trying to regulate with commercial laws? I mean, this is antitrust law and consumer protection, ostensibly, but they're going after these medical associations for what they're saying about gender identity. They're going after companies in the advertising industry for this, censorship industrial complex. What the complaint is that companies like ours are working with advertisers to censor conservative sites specifically. That's the complaint. That's what's political about it. That's what's siege about it. And you can see that because of the effectiveness of bringing these regulatory actions on these companies, FTC has gotten pretty bold about it. Like, they sent a letter to Apple saying for Apple News, maybe there's consumer protection cause in there for them to give Apple a hard time because they're not showing enough conservative news in Apple News. I mean, the Cato Institute, I don't know if we have anybody from that group out of here, but the Bleeding Heart Progressive Liberals at Cato Institute wrote in defense of Apple that this is like not worth the argument is not worth the paper that it's written on. Like the allegation of the loose tie to FTC law, consumer protection law, was like, maybe it violates Apple's own terms of service to not be showing enough conservative news. Are you kidding me? This is so blatantly pretextual. So I think the effect is that because they're able to get some folks to do what they want, they'll say, well, let's see what we can try. Let's see who we can send letters to just give a hard time to.
Can I add one more thing, Renee, which is one more thing that it shows is that the FTC in its actions really is beyond the pale. And I say that because maybe we'll talk about the next panel will really talk about this case. A federal district court judge in Texas recently ruled that even if everything that Andrew Ferguson has accused us of doing and advertisers and agencies colluding and targeting conservatives, even if all of that were true, it would be perfectly legal. There's a long line of cases that says boycotts are legal. And in that case, it was X sued the World Federation of Advertisers, as we've described before, and a bunch of blue chip advertisers. And the judge dismissed that case by saying, even if every accusation that X made, which was that the advertisers got together, they colluded, let's not advertise on X, even if all of that were true, it would be perfectly legal and perfectly understandable. Those brands did not want to be associated with Nazi content and other content that had been found on X, perfectly reasonable. So I think another effect of this is really to undermine any notion that the FTC is expert even in its own area of antitrust. At the end of the day, they've built all of these cases, the CID, the consent order, everything, on some theory that there is some collusion that we're not involved with, but there's some collusion that would be unlawful. And the judge ruled even if everything the FTC claimed all of this time were true, it would be legal.
I want to ask, do you have any questions in the room? Is there anybody who wants to ask a question? Okay, Dean, we're back there.
Can you hear me?
Yes.
Right. I'm not afraid to shout. This is such a great panel on such an important topic. Berin asked me to also very quickly just maybe put a point on the congressional investigations piece of this. My name's Dean Jackson. I was formerly a congressional investigator with the January 6th committee. I was principally in charge of the investigation into Facebook, YouTube, and Twitter. Just as a fun aside, those companies all took dramatically different postures when interacting with us. And Twitter's response was actually to tell us all of the things that you're asking for in a conditional subpoena or First Amendment to go pound sand, which is how they did turn over some things to us rather cheaply, including all of Jack Dorsey's junk email. So I spent a while rifling through that and eventually found other ways to learn about the intersection between Twitter, which later became X, and the insurrection. But my question about this really is, I have two questions for you. One is, first off, what reforms can you think of what pathway can you see to deterring government actors from using this power this way? Because in an environment where there's no appetite for checks and balances between the branches, it strikes me that any use of state investigatory powers can be accused of being a cudgel, right? I mean, we certainly were accused of using our investigative powers as a cudgel against the tech companies and other actors. And now we've seen Jim Jordan use his investigative powers, I think, very much as a cudgel. Well, my second question is kind of more tactical and direct and maybe hopefully easier to answer. What would help you most, or what would have helped you most when you find yourself in the position of receiving these demands? Are there forms of collective or targeted assistance that would be a difference? Crovitz mentioned pro bono legal assistance. I know a lot of us have talked a lot about the need for collective public support in media and in the public sphere and conversation. There may be legislative or regulatory reforms, but I would be really interested in kind of what you see as ways of slowing down a train that I think is very much heading toward this is a successful and rapidly spreading technique for beating the opposition into submission with the tools of government. Thank you.
Thanks for the question. I can do that first. And I think the most important thing to your first question is that folks have to fight back. It's the primary thing. We keep thinking about power is, the government power, like legislative, executive, judicial. Yes, those are those three branches. But then there's other sources of power in our society. Individual people, like acting collectively, like in protests. That's a form of power. Companies have enormous amounts of power and money. And it's just alarming to me when really big ones with a lot of power and money are just like, well, why don't we just stay quiet? And we don't want our shareholders to get mad. We don't want to cause any waves. We want to stay out of it. We want to stay apolitical. Again, every time you try to stay apolitical, the politics comes for you anyways. So having companies stand up, but it's also like academia, think tanks, the press that support the state. All of these are centers of power, and folks need to realize that that's what they should exert it in the ways that they are able to as members of society. And what has helped us is like a community like this, which is not, I'm in Colorado, y'all are DC folks, everyone's yes, of course, we all get together with think tanks and the law schools. That's not the case outside of the Beltway. But it's been really helpful to know that there are folks that fight these battles to make sure that no one aspect of society. In this case, the whole of government becomes too powerful.
Yeah,
I agree with everything that was just said, and I guess I would add that I've been particularly disappointed to see so many large companies respond to jawboning by accepting the jawboning. We end up with situations, as Vanessa described earlier, where even a company like Apple is accused itself of being biased. By the way, I looked at its terms of service to see if there was any case, and it took me 30 seconds to see that there were no assurances in the terms of service relating to the content that a reader would see. Any junior paralegal at the FTC would have seen that there was nothing in the terms of service that would have justified what the FTC did. It's ridiculous. And I would have liked, as the former publisher of the Wall Street Journal, I would have liked to see big companies take a firmer stand. I do have one practical recommendation, which is that we've had to pay our own legal fees this whole time, whether it's to deal with congressional investigations, where our law firm, as I'm sure you in Washington understand, but came as a shock to me, they have people who are expert in preparing corporate executives to testify before Congress. Amazing to me. And we did. We spoke to every congressional committee that contacted us. We explained what we do, and they went away, didn't pursue any of their requests, but still wrote about us in ways that were false. But my particular proposal is that we rethink what immunity looks like and have some concept of limited immunity for government action that leads to a federal court, maybe particularly in a preliminary injunction or some other equitable relief procedure, finding against it. It would be some disincentive for the FTC to have to pay my legal fees when I win this case. And I think that would be a good reform.
Yeah, I agree with everything that's been said so far, and I'll just say kind of two things more. The first is, this does feel like a moment where not only are we needing to fight back at every juncture, but where unlikely partnerships across the ideological spectrum are particularly critical to that, right? Like, I don't need everyone to agree with me on every trans rights issue for us all to agree that the FTC shouldn't be telling medical associations how to develop their standards of care, because that ultimately has much broader implications for medicine in the country and our healthcare in the country, and what authorities the Federal Trade Commission should or should not happen. And so, one of the things we really focus on, and would invite everyone here to either reach out to me or continue to do on your own, is look for those opportunities for kind of cross-ideological partnerships in the fight. And then the second piece, similar to Gordon, is always pro bono legal support is just incredibly critical. On the trans healthcare front, the CIDs right now are limited to the 3 medical associations, but all signs from the administration, including a very specific USA job posting, suggest that this is just the first foray into these investigations. And so we imagine that providers and local community health centers will likely be on the receiving end of these CIDs, depending on how the litigation goes, and a lot of them will need pro bono legal support.
I'll say also, Stanford recovered my legal fees for the civil litigations in their alternate. My First Amendment has been just so extraordinary in promoting legal representation in my fights with Congress. I want to just make one other point, which is that media coverage and think tank articles and explainers on how this works actually really do matter. And they matter for the unexpected reason that AI answer engines synthesize this stuff. And I will say that, I don't know how many of you guys noticed that Eric Schmidt got a consent decree in Murphy v. Missouri 2 days ago. He lost. He got a participation trophy, right? Every right-wing media outlet trumpeted this as if they had just won, as if the entire case had been proven, as if it was just the biggest win for the state of Missouri in the history of American jurisprudence. And every right-wing media outlet told that story, and that means that is what is returned when you search for that case. That narrative was immediately entered into Wikipedia in every conceivable, the Twitter files entry, his entry, the Murphy case entry, Matt Taibbi's personal bio entry, you name it, they are out there and they are shaping the narrative. There is nothing happening like that on the other side. If you search for my case, slice of litigation, the only stuff that comes up is the right-wing media takes, and that's because these are not major cases, which means that what you see is what the media that wants to shape perception, that is the story that they're telling. The court filing is for narrative shaping, and that is something that I think, people who think about courts as a place for fighting for justice, or think about investigations as a place for actually uncovering wrongdoing or trying to figure out reality, that is not how these things are being treated. They're being treated as narrative formation exercises that can support of scaffolding for a broader story. And when that story is being told, that is what is landing in everything from AI answer engines to search engines at this point. So this is a thing for people who write or tell stories. I think it's important. I know we are going into our next panel now. So I guess I'll just ask one very, very quick, 2-second, very short closing question. What should the audience watch over the next 90 days in your cases?
We filed a case. The judge is considering whether we get a preliminary injunction or not. If we get one, that is great. If we don't get one, that's okay. We'll go to trial and we will win there, thanks to Bob Corn-Revere and his team at FIRE.
Yeah, so WPATH, Endocrine Society, and AAP have all independently filed suit against the FTC in U.S. District Court in D.C. All of them have moved for preliminary injunctions. The Endocrine Society case and the WPATH case have oral arguments scheduled for April 7th. No oral argument is scheduled yet for the AAP case. So PI decisions, hopefully at some point in April. And the only other case I would flag for folks to watch is AAP also brought suit in the Northern District of Illinois against the Attorney General of Florida for kind of a similar use of consumer protection law to attack AAP and state law. And a TRO was just issued last week blocking that investigation. And so much more briefing on that front to come.
I don't have a pending case, but on Gordon's case and the NewsGuard case, I think that the key issue I'm interested to see is whether Omnicom's consent order gets ruled unconstitutional, which I think it should be. And regarding the state law issues that Josh mentioned, this is happening in state laws. I mean, there are Florida and West Virginia legislatures recently passed laws saying that essentially the government nor their agencies can use news rating services like ours. So it's happening everywhere.
In both cases, Vanessa, I don't know if you know this, in both cases, the lobbyist was Newsmax.
Yep, it's a Newsmax group.
Thank you very much.
Thank you all for coming. While we're doing our little transition, for those that were playing along at home, a CID, you heard a lot of talk about those today. We should have defined. That's the FTC's investigative tool. They're civil investigative demands. They're not subject to the normal process. So we'll hear about today from the rest of our panel, please, that gets some review in federal court. I have some slides I'll go over to provide you a little bit of context while we're doing a transition. If you go to slide 7, while everyone else is sitting down, I have one slide that just lays this all out for you so you can see how these cases fit together. So we've been talking today about 2 categories of cases. There's the first 4, which are all about somehow there's some vague theory about competition. And the FTC has been involved in some of those cases. And then we have this set of claims about gender care. But anyway, I'm Berin Szóka. I'm going to turn things over to my colleague, Bilal Sayed, who ran the Office of Policy Planning at the Federal Trade Commission and is a veteran antitrust lawyer to moderate. Okay, if we're ready to begin, I will introduce our panelists.
I think we get them. Yep, we have the ones. Do we have Bob? Bob's on Zoom. Yeah. Okay, there he is. Okay, thank you. Okay, and Joshua joining as well. Okay, so on the screen, we have Joshua, who you met earlier, so I won't add any more. We've got with us Solveig Singleton, who's from Cato, who I understand is an expert on CIDs or on paper coming. Also on the screen, we have Bob Corn-Revere from Fire, who is busy litigating some of these cases. To my right, Dan Greenberg, also of Cato, who has filed an amicus brief in the Media Matters case. And Berin, of course, introduced us. Berin is the president of TechFreedom. So, Berin, maybe I would like you and Solveig to talk a little bit about CIDs, the enforcement mechanism, the scope of when a CID can be issued, and what the standard of review for a CID is before we get into some of the details of the cases and the law.
I had a slide about this on the FTC. You want to start with general?
Sure. I'm going to start with some very general background. So under the First Amendment, Media Matters and NewsGuard and GDI and the other targets of these CIDs, I think have a very good chance of success. Others are going to talk about that in more detail. But this First Amendment lifeline is in a sense a very slender thread. And that's because in the big picture, generally, when they issue subpoenas in a civil context, administrative agencies have very little accountability. And this particular First Amendment crisis has been essentially brought to you by the modern Supreme Court rulings that have reduced protection we should be getting from the Fifth Amendment and from the Fourth Amendment. So to talk about the Fifth Amendment first, that is the right against self-incrimination. It will normally apply only in criminal cases or in civil cases where the penalty is considered punitive or where there might be criminal uses of the information further down the road. But the modern court has held that it doesn't apply to business records. It can't be used by corporations, and it doesn't protect documentary evidence as much as it does oral testimony. So essentially, in this business context, it's not really available to the targets of these CIDs. There are some good arguments that all of this is contrary to the original meaning of the Fifth Amendment. So the Supreme Court could adjust this, but as it is, it's not currently very useful. The Fourth Amendment will also apply. That's the privacy rights. And that will normally apply when the government is searching your premises. Now, of course, a subpoena is not the same thing as a physical search, but it could be used as a substitute for a physical search. So it is considered a constructive search. But the modern court doesn't consider this very intrusive. So there's no requirement of probable cause. There's no requirement that the government have a reasonable suspicion before they issue such a subpoena. The subpoena only needs to be reasonable. That is, within the scope of the statute, which is generally very broad, and it can't be too burdensome. But the barrier to showing that it's excessively burdensome is extremely high, and it can't be issued in good faith. In bad faith, to harass. Now, I think the media tech companies here have a good argument that this is a bad faith use of the CID. But in these Fourth Amendment cases, courts tend to defer very heavily to the investigators. And so any claim the investigators make about the facts or legal interpretation, they will tend to get the benefit of the doubt. So it's very hard to win these cases using a Fourth Amendment argument. Essentially, what will, I think, save the CID targets here is that they're media entities or advocacy entities that are clearly engaged in free speech. The free speech problem is hard to deny. And furthermore, the FTC officials have been very, very outspoken about what their motives are. They told everybody what they're doing. If they'd been more subtle, it would be much harder for the CID targets to have any kind of relief at all. Or if these were non-media companies, say if you were a bank and you had testified against an agency saying that its policy was a bad idea, you wouldn't have a very easy time getting relief, even from a very broad CID. So the Supreme Court originally justified this very lax Fifth and Fourth Amendment scrutiny by comparing administrative agencies to grand juries, which get a lot of leeway in their investigations. But essentially, a grand jury is a very different thing. It's made up of ordinary people. It's very targeted on it's under the supervision of a neutral judge, and it's looking for an indictment. It's not going to generally be trying to harass people for political reasons. So I think in the case of administrative agencies, the comparison to grand juries really does not work very well at all. And I think it would be good going forward if Congress and the Supreme Court were to consider something like requiring an agency to articulate particular facts, giving rise to a reasonable suspicion before they issue a subpoena. And there's other possible reforms as well. I'll turn it over to the other.
That was really helpful. Solveig, thank you for doing that. So I summarized here just the FTC's investigative powers. This is really the heart of what we're talking about here today. But let's go back just to where we started with Andrew Ferguson, right? Andrew Ferguson told us how the weaponization of investigations works. He says he's describing what the government could say in general. So again, he says, the government would say, well, we have a tremendous array of investigative tools. These tools are expensive when applied to you. So even if we don't win at the end of the day, knuckle under. That's exactly what he's doing. Every accusation, of course, is a confession. This is projection all the way down. If you go to the next slide, you'll see the FTC's investigative powers here. This bears out what Solveig has been saying. Solveig talked about probable cause being the usual standard for investigations. That's not the standard for the FTC's use of its civil investigative demands. The standard is very low. When the agency has reason to believe that there's relevant material, it can issue a CID. And it's understandable because in the normal course of business, normal course of what the FTC does, we want the agency to be able to investigate cases. We want them to have an easier time than a normal antitrust plaintiff because they're supposed to be there to provide a backstop. The problem is when this goes awry. So if you go to the next slide, you'll see there's a structure inside the statute. So right now we're going to talk about petitions to quash. That's governed in the statute. The agency can file for petitions to enforce. And what the statute says is the courts review the petitions to enforce that are filed by the agency. The statute doesn't govern who reviews petitions to quash CIDs. And this becomes really important for where things stand on the media matters, which I think maybe sets the table for our discussion today, which is this has been litigated. This was litigated last year. Media Matters, if you remember my slide that I started with, Media Matters is one of the nonprofit organizations. If you go to slide 7, we can see this all together. Media Matters and the Global Disinformation Index were nonprofits, or are nonprofits that investigate lawful but awful speech, and they share their opinions about those things. Some of those opinions have been used in rating media outlets like Breitbart. Media Matters was the target of its own series of harassment, and last August, if you go to slide 12, Judge Sooknanen in the DC District Court ruled on the legal challenge because they moved to quash at the FTC. The FTC, of course, denied their petition to quash. They brought a suit in federal court. The judge said the court has jurisdiction to review the CID. The Administrative Procedure Act normally is useless here because that only provides review when there's a final agency action. Investigations are not final agency actions, but the court said that's okay because they can review this as a First Amendment matter, and that Media Matters is likely to succeed on the merits. Just briefly, if you go to the next slide, it's not worth spending a lot of time on, but if you're a law student, you want to read this case, you should. And what it discusses is there's another case that basically governs when federal statutes provide exhaustive relief. Case is Thunder Basin. The court said that doesn't apply here because the statute, as I just mentioned, it doesn't provide for judicial review of motions to quash. That's left up to the federal courts to handle on their own. So we skip past that. We go to the next slide, and she says that she's going to issue a preliminary injunction to block the investigation. Why? And this gets back to Solveig's point. Solveig talked about, is there probable cause, right? So that would be a question of what are the merits of a claim? That's not what this case was resolved on. This case was resolved on whether Media Matters was likely to succeed on their First Amendment claim, right? On showing that they were being harassed. And this is a completely different question, right? So there are two ways you're here today we could approach this. One is to question whether the agency is bringing a valid suit. And as you already heard, Gordon put this very well in the GARM lawsuit that was just ruled upon. The court said there's no valid suit. We'll get to that later. That's one way to deal with these potential abuses. And the other way is there a First Amendment violation here? And just briefly, in that case, Judge Sûgnanen said, yes, the company or the nonprofit was engaged in First Amendment activity. The FTC engaged in a retaliatory act. Their speech was chilled, and the retaliatory animus was the but-for cause of all of that. So those are the two branches of our conversation today. I hope we can unpack them in our discussion.
Yeah, I think we will. I want to make a couple of comments, maybe Solveig, maybe you, Berin, maybe you can respond to. I think my recollection from practice is that the CIDs issued by the FTC are not self-enforcing. So even granting that the FTC will usually not quash the CID that they itself issued, the parties do not really have to respond, and the FTC can only force compliance by going to a district court. And that's where some of this litigation comes up, right? And I think I'm not suggesting in any way defending the FTC's actions here, but I think it is important to suggest that there is some protection for the agency, for parties or recipients of CIDs that are overbroad or perhaps even issued without merit, in that it is the FTC that has to force compliance. It itself cannot force compliance.
Can I respond to that? So that's exactly right. And that's exactly what's being litigated right now, because I referred to the district court decision. This is currently before the DC Circuit. Oral arguments are April 13th on exactly this question. And if you go to slide 13, I clicked what the district court judge said about this, which she says the FTC argues that a recipient of a CID that violates the First Amendment under the FTC's argument could only challenge that CID if the FTC chooses to bring suit itself, right? That's the thing that the statute provides for. It's the petition to enforce in federal court. And she says, nothing in the FTC Act suggests that Congress meant to declare open season on journalists by allowing a retaliatory agency to decide if and when its retaliation will be reviewed by the federal court. In other words, you don't have to wait for the FTC to sue to enforce. That is the question that's going before right now. And I would just say, Dean asked about statutory fixes here. If the DC Circuit agrees with the FTC and says there's no judicial review until the FTC tries to enforce in federal court, we need a statutory fix. You already heard today, NewsGuard laid out, they were never subject to a petition to enforce, but they were effectively forced into these huge legal fees that accounted for 30% of their revenue just to fight back against the FTC before anything went to a federal court. So that is not a workable answer that we have to wait to federal court. But if that's what the DC Circuit says, the ball's in Congress's court. I would hope that the DC Circuit will understand that if the First Amendment means anything here, it's that the chilling effects will already have occurred and almost no one will ever sue. It'll be too late. So the First Amendment won't mean anything if you have to wait until the agency goes to federal court to enforce its petition.
One possible reform that's been put forward, not of the FTC power, but of another agency, is to have it changed by statute so that the target of a CID may appeal directly to federal district court from the denial of a petition.
A petition to quash.
Yes.
And that's effectively what the DC district court did here. They effectively said there's an implicit right to bring that challenge. So like your point is it's not explicit.
Yes, and I think that would be another difference between the Fourth Amendment challenges and the First Amendment challenges. Here, where a court is very concerned about the immediate effects of and the chill on free speech, they've allowed the suits to go forward. In a Fourth Amendment suit, they might actually be requiring the targets of the CIDs to wait until the agency sues them.
And the difference between those two things is whether there's evidence of retaliation against speech or chilling effects.
That's what I understand it. Yeah.
So I'll make two other points before we sort of move a little bit to the substance, and one of them is related to the substance. As Berin indicated, you know, in the what you might call the normal case, there probably is a reasonable basis for the FTC having, you know, broad CID power. They are an investigatory agency, and often they begin investigations after a relatively after being a relatively low bar of identifying or hearing about concerns, and then they're investigating them. I think one of the issues here, of course, is it looks like, and I agree, that many of these companies are being targeted on non-meritorious basis. I'd also note it is in dispute whether there is First Amendment protection for some of this conduct. Now, I believe, you know, the position the agency has taken is probably not the right one, and Berin and others have done some excellent work on that. But you know, I will say, at least at the margin, the question of whether the First Amendment protects conduct as opposed to expression is sort of a question that has sort of been litigated, and the agencies, the Antitrust Division and the FTC, are at least attempting to suggest this is conduct and not expression. I'm not suggesting I'm giving it a lot of credence, but I think, you know, as you think about these issues, it is not always obvious if the courts will treat what we might believe is expressive behavior as expressive behavior and not conduct, right? Which has less protection. So with that, to make sure everyone is sort of up to speed on what some of the conflicts are outside of what may be targeting speech decisions. Bob, can I ask you to describe sort of your litigation effort and sort of the substance of that litigation effort, and where what defenses, say affirmative defenses, you're offering on behalf of clients and other interested parties?
Well, thanks, Bilal. Can you hear me okay?
No, please speak up.
Should I? Okay, I'll shout then. Thanks for that. Let me just say that I think Gordon on the first panel really laid out what our litigation is about. It is a challenge to the FTC's investigation of NewsGuard, and it has two aspects to it. One is to the very broad CID, very much like the ones you've heard about for the others, demanding every scrap of paper created by NewsGuard since it was created in 2018, seeking client lists, information about subscribers, seeking everything that is done inside NewsGuard for how and why it rates news sites the way it does. It is exceedingly intrusive. And in addition to that, something that does not pertain to the Media Matters cases or others, is we also have the conditions imposed on the Omnicom IPG merger that prohibit them from doing business with NewsGuard, and specifically conditions that were added at the behest of Newsmax that target NewsGuard with the precision of a laser beam. As Gordon explained, when the conditions were first proposed, it prohibited doing business with sites that engage in rating news sites based on ideological or political perspective, something that simply doesn't apply to NewsGuard. But when Newsmax pointed out that NewsGuard would not be covered, then the revisions to the consent decree specifically targeted rating based on news. So purely focused on NewsGuard and essentially trying to suffocate it by strangling that part of the NewsGuard's business. The challenge that we brought targets both of those aspects of the FTC's campaign. And here, there's no question, as Solveig mentioned, of the motivations involved. The chairman of the FTC has been quite upfront about going after NewsGuard because of what he sees as a political perspective he dislikes. And as a consequence, it's hard to tell which is thicker in this case, the hypocrisy or the irony. All of this is being launched based on a claim that the previous administration, the Biden administration, had been engaged in jawboning and muscling social media platforms. And it was described as the censorship industrial complex. And in that regard, we at FIRE didn't disagree that that was a violation of the First Amendment. As a matter of fact, we filed an amicus brief in the Supreme Court challenging the Biden administration's actions in this regard. So when you have government officials leaning on private actors, trying to tell them that they should change their editorial practices, that's the definition of a First Amendment problem. And now you see the current administration doing exactly what they claim to abhor based on the previous administration. To speak to the point that Bilal brought up just before about whether or not this is speech versus conduct, this is quintessential First Amendment conduct that NewsGuard is engaged in. It is rating news sites in the same way that Consumer Reports would rate products or a movie critic would rate a movie. This is done expressly on journalistic factors, transparently disclosed, that tell viewers what to expect when they come to a news site. Does it on 9 different factors. The scale is out there for everyone to see, and that is quintessential First Amendment activity. That goes to the elements of retaliation that we've seen in this case. First, are you engaged in First Amendment activity? Yes, absolutely. NewsGuard is engaged in First Amendment activity. Secondly, is the action taken by the government the kind of action that would deter a person of ordinary firmness? Yes, it would. As Gordon explained, and as Berin mentioned earlier, NewsGuard, just in attempting to cooperate with the FTC, has expended 30% of its revenues. It's a huge burden, and it would still be going on if not challenged in court. I do take the point that the FTC cannot enforce these CIDs in court until it goes to district court, but that was the point that was litigated in the Media Matters case. If you're inflicting First Amendment harm before the FTC would even decide whether to go to court, then you should be able to have a judicial remedy. And so we're seeking it on that basis. And the third question in any retaliation case is whether or not there's a causal link between the actions of the agency and the harm that's taking place. And here there's no question. The irony of this administration is that they're not bothering to deny their motivation. allegations. They're shouting them from the rooftops. And so the question is whether or not there will be an adequate judicial remedy. And that's what we're seeking to find out in district court.
Dan, let me ask you a follow-up. Cato filed an amicus brief in the Media Matters matter. I'd like to get your thoughts on why you filed the arguments, how the court treated them, and then I have a follow-up question. I want to let Josh get in here, but I have a follow-up question that at least I'd like to get a response on it on the record. But talk to us about the brief.
So I think that I think that one question that is very difficult for courts to resolve, one issue that's very difficult for them to explore is what jawboning is. And more precisely, I think we have a rough idea of what we're talking about when we talk about jawboning, which is enforcement or coercion through informal channels. But the difficulty is that it's very difficult to come up with the definition of jawboning that's not either over-inclusive or under-inclusive. And so, it's somewhat similar to Justice Potter Stewart's famous remark in his concurrence in Jacobville, when he was explaining the nature of obscenity. He said something about hardcore pornography, and he said, "I know it when I see it." And he said later on, I regretted writing that for the rest of my life because it doesn't really explain it doesn't define or draw lines in any strong sense about the phenomenon that I'm wishing to identify. And we have a problem with our jurisprudence on jawboning. When you look at how the Supreme Court has attempted to draw lines, you see some unsatisfactory answers. You can see that Justice Alito, in his Marthy dissent, tried to come up with a framework in which he came up with 3 tests, and they're a little vague. He asks, did the allegedly jawboning officials have authority? What statements did they make? And what was the reaction of those who were subject to being jawboned? In Fullo, the court hints at a kind of a 2-factor analysis, which is what is the power of government and were those statements coercive? But there are going to be large difficulties because the court doesn't want to be over-inclusive when it's trying to figure out what crosses the line. Because this really may be a question of degree where line drawing is very, very difficult. That was really the force of our amicus brief. There are some related issues about the limited powers of administrative agencies that I'd be happy to get into if we have time. But I think you said you have a follow up to the.
I have a few questions that I'd like people to consider just to address what I think are the full scope of the arguments, the FTC, and in slightly different situations, the Department of Justice and the Antitrust Division are making. One is with respect to some of these claims, the FTC is proceeding on a competition competition theme. With respect to others, including the sort of the medical advice, trans children, all in the effort, they seem to be proceeding on a consumer protection basis. I'm wondering if that makes a difference in how to think about this. I also want to flag, I think something we haven't talked about clearly, which is the agencies occasionally recognize in this area there may be a difference between unilateral conduct, right? Decisions to do or not do something that are made by a single firm without agreeing with others, and decisions to work with, not work with, do, not do things collectively. And I wonder if we can address maybe both of them. Does it matter whether they're proceeding under a competition theory or consumer protection theory? And does it matter that some of the activity they are, say they're focused on or concerned about as a law violation? Does it matter if that conduct is unilateral or collective? And I want to get Josh in here.
Yeah, can I tee things up? Because I think we have to start first.
Okay.
Sure. So you go to my slides, slide 4. The Supreme Court has never said that media companies are immune from generally applicable laws. Of course, they are subject to the consumer protection laws and the competition laws. And you can go back to U.S. versus Associated Press, where the Supreme Court dealt with this question about whether the AP, in allowing its member newspapers to veto the entry of new newspapers into this press pool, was violating the antitrust laws. And the court said that the publishers are businessmen like any other businessmen, and they're not immune for their business practices. So, well, my question for you, or my answer to you, is it depends what we mean by business practice. And I think the red line that I draw in my work is between First Amendment speech, editorial judgments, and business practices. So in Net Choice versus Moody, which is the case that struck down or indicated that almost certainly the laws enacted by Texas and Florida would be struck down, the Supreme Court had this aside where they said the government can take various measures like enforcing competition laws to protect access to speech. But in case after case, the court has barred the government from forcing a private speaker to rejigger the expressive realm, because it's no job for government to decide what counts as the right balance of private expression, to unbias what it thinks is biased, rather than to leave such judgments to speakers, their audiences. Again, this is the red line, right? You can see here, right? If you lie about, let's say, how much your subscription costs, or whether you bury whether it's automatically renewed, and subscribers to the Atlantic end up seeing charges that they don't expect, of course, that's subject to the consumer protection laws. But if you go to the next slide, in these two cases, Omnicom and Garn, I think we see that red line being crossed very clearly. So Gordon referenced this earlier. I'll just briefly touch on it. The Omnicom settlement, we had a merger of the two largest providers of ad buying services, ad agencies. They agreed, as the agreement was rewritten by the FTC after lobbying from Newsmax, that they wouldn't make any advice to their clients on these covered bases, which include not just political judgments, but the assessment of the veracity of news, including from standards established by third party, which is groups like NewsGuard or services like Adfontes, right? That's not about a business practice. That's about making editorial or judgments about speech, right? This is no different from what you do, as Gordon said earlier, when you post a review of a business. When you go out for dinner, you post a review. You're expressing your opinion. This is about expressing opinions about the veracity of news, about what constitutes journalism. This isn't about business practices. This, to me, is an easy example of crossing a red line. And if you go to the next slide, what I would say, just to wrap up here, is largely the courts haven't had to address these First Amendment questions. And instead, what they've dealt with is, what are the limits of the antitrust law under its own doctrine? It's federal questionable. In the Garn case that was just resolved last week, what the court said was that the two theories here are either that social media companies, other social media companies don't have to compete with X because of the advertisers are boycotting X, or that the advertisers who no longer compete with X, they pay more when they buy ads from Pinterest. And what the court said was neither one of those is a cognizable antitrust harm. The court didn't get into the First Amendment. They just said it's not a cognizable harm, and they wrote the opinion in a way. I think the answer is, it doesn't matter whether this is group conduct or single firm conduct. If you have a single advertiser who refuses to do business with X, they're not hurting a competitor. They're making a judgment that they're willing to pay more to buy advertising from someone else because of their principles. That's a First Amendment protecting judgment.
So Berin, I'm skeptical that the Garm litigation is over.
Oh, it's not.
So who knows? But I think in the end, I don't disagree. But the case you mentioned, Associated Press, you characterize it as business conduct. I agree with that. Superior Court trial lawyers, which was what you might call a horizontal boycott by DC public defenders, with all their services unless they received higher compensation, was also treated as a conduct case by the Supreme Court, but not entirely treated that way by the DC Circuit. And so I still see a split in some respects between the enforcement against this application of the First Amendment, the single firm conduct versus group conduct. Now, doesn't mean it won't be extended that way. And I think that this is really a question or statement masquerading as a question. I think one path I have not seen thought through is that the Supreme Court and the appellate courts did not make this distinction of single firm conduct versus collective conduct in the Noor Pennington petitioning cases, right? They don't. One thing you see the division, Department of Justice, and I think the FTC doing, is saying collective action, right, is almost by definition conduct, and that's where the antitrust reach comes from. And what I'd like to see is some development of this idea, or maybe dismissal of this idea, that the courts have sort of already addressed this, Supreme Court addressed this, the appellate courts, in not making that distinction between single firm and multiple firm petitioning and protecting it, even if it's anti-competitive petitioning in the North Pennington case.
And the answer is really very simple here, right? The First Amendment not only doesn't make distinctions about whether you are working with someone else to do something, but it actually protects the right of association, right? The First Amendment, of course, protects your right to speak with other people and your right to associate with them. The distinction that matters for the First Amendment is only the distinction between speech and conduct. This question of whether it's one person or J persons is completely irrelevant. And if anything, actually should be helpful in making First Amendment argument. To answer your earlier question, to set things up for Josh, I think that same analysis applies whether the theory is a consumer protection theory or a competition theory. There could be a valid claim in either case, right? If a provider of gender affirming care makes a misrepresentation about its services, it is providing a service, makes misrepresentation about that, of course, like any other marketer of commercial services, I should make a distinction between providers and marketers, and Josh will do this better than I can. But if you're marketing a service and you make a misrepresentation about it, of course, that is potentially actionable, just as it would be if it's Apple News doing it. The question is, what's the representation? Apple News, of course, doesn't represent that they're providing an unbiased, balanced service. They market themselves providing curation, just like a newspaper does. It's exactly the same claims, and the courts have consistently refused to allow consumer protection claims to be brought on that basis because they're not objective statements of fact that can be quantified and decided by courts. They're statements of opinion. That's the line that's relevant.
Yeah, I'll just jump in on that point and say I think that's exactly right. That what we're dealing with in the trans healthcare context is not commercial speech or speech aimed at consumers, even in the first instance. It's nonprofit medical associations that are compiling scientific evidence and either putting out their views on a matter based on that evidence or what they view as best practice. And so, the First Amendment kind of core rights we're talking about that have been implicated by the CID include the right to associate with other providers to compile and curate that information, the right to debate that information and present one's views on it. And then, implicated by some of the specific requests in the CID, including to, WPATH, is just the right to petition a court and express one's views on an issue to a court. WPATH and the others have received requests from the FTC for all documents related to those representations made in court. And so I say all of that as just a way of saying, I think in the trans healthcare cases that are currently teed up, we're so far outside of the context of what consumer protection law is aimed at, that we really are just in kind of core First Amendment territory. And I think it's why the plaintiffs in those cases have also like been really honing in on the First Amendment retaliation claims that are similar to the ones that Bob talked about in the context of his case earlier.
Solveig, I couldn't help but see you writing down some things. So I want to give you a chance to get back in here, maybe comment on what you've heard.
I guess I want to say that whether it's an antitrust claim or a consumer protection claim, there is an idea that comes up in many different types of legal cases, and that is the question of whether someone is acting in good faith or acting in bad faith. And I think in this case, and it can be a very slippery distinction, and it's hard to come up with evidence, but in this case, I think a court would begin to hear what has happened and say the agency is not acting in good faith, trying to put together an actual antitrust claim. They're harassing someone for political reasons.
I wonder if anyone can comment on this. I couldn't help but read newspaper stories on the grand jury's subpoena that went to the Fed and the district court's sort of, I'll call dismissal of that subpoena, where the district court Judge Boasberg said, look, I don't have to approach this with, blinders on, naivete. I can see what the president has been saying, and I can see what the Justice Department is doing. It's very clear what's happening. Are we going to see language like that in these cases around the FTC's CIDs? Or reflected on the language of Andrew Ferguson? We haven't really talked about the tie between Andrew Ferguson and the administration, if there is one. But I wonder why. I hadn't heard that in this discussion in both the earlier panel and this.
I'll just let Ferguson speak for itself. Well, Bob,
I was just going to say, I think that has been a constant strain running through all of these cases. If you look at the Media Matters cases, and particularly Judge Soupnan's opinion in joining the FTC, she went out of her way to highlight a number of the basically extra legal statements, the statements out in the public sphere, describing exactly what the FTC was going to do and why it was doing it. And that has been an increasing theme among judges looking at recent regulatory actions, essentially saying that there is no longer a presumption of regularity when agencies act in an irregular way. And you see that in a number of the cases involving the executive orders involving law firms, universities, and so on, where courts are simply saying that they cannot presume that the actions being taken on these bases are presumptively legitimate. And as a consequence, they are looking at these public statements and then issuing orders on that basis. Separate from that, I just wanted to address one of the points that Dan had raised about not being able to identify jawboning with any sort of precision. And I think here, at least with respect to the NewsGuard case, I think we really can, where if you look at the recent Supreme Court decision in NRA versus Willow, we're talking about a decision that was unanimous, upholding the decision of Bantam Books versus Sullivan, and saying that that kind of government pressure constitutes jawboning. The court did try and identify some sort of multi-factor test that would allow people to precisely identify it. But I think in this case, the facts of NRA versus Willow are really right on point here. Because if you recall, in that case, the director of financial services for New York, had been pressuring insurance companies not to do business with the NRA because New York as a state had decided that it disagreed with the NRA's message and it was going to use its business relationships with insurance companies as a point of pressure to undercut the NRA financially. That is precisely what is happening here, where you have the FTC going out of its way to impose conditions on a merger that targets NewsGuard. And the whole purpose of that is to undermine NewsGuard's business. Here, it is unmistakable the fact that unconstitutional jawboning is going on.
Well, I think you keep harping on the presumption of regularity. Right? The presumption of regularity is about assuming what's going on is about law. And if, for example, the FTC had taken a different approach here, and suppose they had done what you did when you ran the Office of Policy Planning, you ran 23 workshops about something, about the agency's authority. Those were really thoughtful, right? They were intended to explore how the agency could grapple with hard issues before it, right? You could imagine a different timeline where the agency did workshops like that. They wrote reports, they wrote a policy statement, they tried to articulate what the legal theory would be. And then they brought investigations as a prelude to enforcement. And there was a well-developed legal theory behind what they were doing. That might look different. Here, what happened is there's no legal basis, there's no articulated legal basis at all. The closest we come to it is 2 sentences in Andrew Ferguson's statement about the Omnicom settlement. And then the legal arguments that X made when Mark Mandar was now an FTC commissioner, he was one of the counsels, not to the suit that X brought, but to a parallel suit brought by Rumble. So we know those arguments. Those arguments were the ones that were just rejected by a district court, as you know, that's sued up to the Fifth Circuit. But they were essentially laughed out of court. And instead, what we have instead of legal theories, we have a literal campaign document that Cultural News released, a 2-page document where Andrew Ferguson made a series of promises to the White House in bullets as to why he should get the rose and be picked as FTC chairman. And the bullets, it's not about, win a case. It's not about enforcement. It's not about legal theory. It's protect freedom of speech and fight wokeness. Point number 1, investigate and prosecute collusion on advertiser boycotts. Point 2, and Lena Khan's politically motivated investigations. Point 5, fight back against the trans agenda. Investigate the doctors, therapists, hospitals, and others who deceptively push gender confusion, et cetera, right? These are not assertions about legal theory. These are, we will investigate, and it's the other side that is politically motivated in their investigations. I mean, he's written the script for the courts to find political bias. The reason I remembered about that conversation with Eric Posner is because Bob, in the petition that was put to the federal court about the war against NewsGuard, put that comment front and center. The FTC knows exactly what it's doing here. And this gets back to that point that Solveig and I started with, which is there are 2 ways to deal with this problem. One is, of course, sniff out political retaliation as a First Amendment problem. Well, here it's very clear, and maybe it would be less clear if they followed regular process, and maybe trust the courts to resolve these things, or you actually assess the merits of the theory. And that sounds nice, but it took in the Garden case, it took almost 10 years for that to work out, and that is just too slow.
Okay, so I have 1 or 2 more questions, but I don't know. There are a lot of smart people here. Maybe people who are not so smart but have questions. So I do wonder if people have questions for the group or want to raise an issue that the group can address before we break.
Hello? So on the definition of jawboning, without having to state there's a definition, there's this fact pattern that's emerging in the NRA case and in this case here. So I just want to see if you could think of examples of other agencies where this is happening. So like the fact pattern is like the agency's trying to coerce behavior in an area where they don't have legislative or agency rules-based authority. They're trying to do it in instances where they have other powers over entities that are in front of them.
And they're asserting that the coercive behavior over those entities, and over entities that are unrelated. So here that's the FTC is trying to coerce behavior in like that speech behavior with Omnicom, who they do have power over because they need the merger approved, but they're trying to assert that coercion, not just to Omnicom, but to somebody unrelated to Omnicom. So we see this happening in FTC merger cases, like the news distortion rule and the Friday mergers between CBS and all that stuff. Right. So outside of these agencies, can you think of areas where this is happening right now?
Well, I'll just mention the Antitrust Division, Department of Justice, have filed a sort of a statement of interest in the Children's Health Washington Post matter. So, I mean, this is not limited to what I would call specialized agencies, either sector specific or enforcing fairly small number of laws. I mean, I think the Department of Justice is interested in this, and the Children's Health statement of interest is probably the most clear articulation of that.
And what that document says is that a reduction in diversity of viewpoints in media is a cognizable antitrust injury.
Anybody else? Am I then finding
Or you want to maybe channel that to maybe Dan talking about remedies?
I just see something, the Anthropic case might raise, it has some resonance here, because obviously the Department of War doesn't have the power to tell Anthropic how to behave vis-a-vis other private actors, but it's using its tremendous power to coerce Anthropic's behavior. And Anthropic's claim is that in part because of the speech acts of Anthropic's leadership, critical of Trump administration and its decisions. So
Maybe we can wrap up by trying to ask how those doctrinal limits get challenged to legislation. This they do. Yes. Well, so I mean, I just want to jump off from your point, which is that we can choose to hope that federal judges will spot isolated instances of injustice and try to figure out try to jury-rig a solution, or alternatively, Congress can pass a national anti-SLAPP law. I'm inclined to think that the anti-SLAPP remedy that is established quite powerfully in some states and not very powerfully in others, that allow essentially meritless suits to be adjudicated at an initial level long before expensive discovery procedures take place, would really appropriately address a lot of the problems that we're talking about today. I hear these terrible stories, both in this room and outside, of the extraordinary burdens that people bear when they're faced with claims from government bodies and sometimes from private bodies, where the plaintiff doesn't say with any particularity exactly what the defendant has done wrong. And so these defendants have to face extraordinarily expensive discovery requests without ever having the opportunity to have a neutral third party say, this is groundless. Even if you did all this stuff, so what? The so what argument needs to have a forum far earlier than it ever does, as a matter of course, and that's what anti-SLAPP laws do.
Well, as far as putting my question. Go ahead.
Yeah, so in other areas in government, like with the Anti-Deficiency Act, there is liability for the individual government employee who does something that is outside the scope of their allowed duties, in that case, obligating the government to owe money to someone, basically. Is there any thought that we need to have some sort of personal responsibility, liability against government officials who so egregiously abuse their position and the Constitution? I'm not like a borderline case.
So the question is, should there be should there be individual liability for government actors? Anti-SLAPP laws do two things. One is they advance when someone sues you for defamation and the claim is frivolous. You get a quick hearing in court, Sam noted. The second thing is that the other side has to pay your legal damages. That second thing is useless against the government if it's the taxpayer that pays the damages. So what John's question is getting at is, how do you create a disincentive against abuse, right? This is not a theoretical question. It has been widely reported that Senator Cruz is working on legislation to deal with jawboning. I haven't seen it. Some people have. People I think are sensible seem to think that it's a kind of bill that could actually attract bipartisan agreement. I think this is the right question to ask. What is the incentive ultimately against abuse? If there isn't some individual sanction for the person who's weaponizing the government, the bill is probably useless. Because the other dimension of having to deal with this is to ask, what is the theory? Dan said, you get the theory up front, right? Well, defamation law, it's pretty easy to assess whether you have a defamation case. So that works pretty well for SLEPs, right? It doesn't really work for the FTC because the FTC, particularly on competition, right? It's not a normal plaintiff. The FTC is able to bring suits that are not just about violation of the antitrust laws, but to bring novel theories, right? So they have this broader unfair means of competition authority, and they can try to breathe some life into that, like in the children's health case, right? Wasn't the FTC, Department of Justice, right? DOJ was able to say, well, we think the antitrust laws should recognize a reduction in diversity, political diversity via cognizable injury. That's not a remediable court, can't challenge it. It's not going to be until the court actually gets a rule on this. It could be many years before the Supreme Court assesses that. You could deal with that troublemaking to get a quick remedy on that. But unless we have some mechanism for getting those questions reviewed in court, these agencies are always going to be able to throw out some new theory as to why what you're doing is unlawful and weaponize the investigative process against you. I mean, Solveig, you thought about this. What do you think? What is the targeted remedy here? It's not an across-the-board fix to bring in fourth and fourth amendment rights, fourth and fifth amendment rights.
So I guess one idea would be to adjust the Fourth Amendment cases so that an agency needs to show, to be able to articulate particular facts giving rise to a reasonable suspicion before it issues a subpoena. Another approach would be to adjust the Equal Access to Justice Act, which requires the government to pay a successful plaintiff's costs in suit against the government, unless the government's argument was unreasonable, which I think one might say in some of these cases it does seem to be. Again, though, it's actually the taxpayer paying, not the agency. So I'm not sure. It's not clear how much that would change the agency's behavior. There's other adjustments one could make. For example, one could create some statutory right to petition for relief from overly burdensome subpoenas. And the bond is showing that the burden is extreme or unreasonable to be lowered somewhat by statute. Right now it's very high. And there's other similar adjustments. But I think in the big picture, this remains a very difficult issue because for the most part, judges do not want to inquire into, they don't want to second guess an agency's judgment as to whether or not an investigation is warranted. And when you have a general culture of good faith in the agency and respect for the agency's mission and purpose, that's one thing. But when that culture begins to erode and you begin to have bad faith actions, then you really have a serious problem. And I think libertarians have pointed out for a very long time that powers given to agencies to do good things and to pursue legitimate investigations can also be abused. And for some years, that has often seemed like a more abstract and theoretical problem, and not one that seemed as if it would become a hugely live issue within our lifetime. But now it is. And so I think it does call for a different approach. And I hope perhaps the Supreme Court will revisit some of its Fourth and Fifth Amendment jurisprudence.
I would agree with Solveig's suggestions. And, you know, I think all of those kind of reforms would be helpful. One of the problems with jawboning cases historically has been they're hard to prove because so much of the activity goes on behind closed doors. You don't know when a government official is putting pressure on someone to do some extra legal or unconstitutional act. Now, that doesn't seem to be the problem with this administration, where they're more than happy to make their demands public and to shout their motivations from the rooftop. But one of the reforms that we have supported legislatively is to have a reporting obligation when government officials contact regulated industries to make demands like this. Once you have that kind of public disclosure and you have an enforceable rule for those who would engage in jawboning, then you create more of a basis for bringing actions in federal court. The other reform that we'd like to see is that for there to be an express cause of action permitted for these kinds of jawboning activities. You have the general jurisdictional provisions that allow challenging illegal or unconstitutional acts, but to have something that makes this specifically a cause of action would be, I think, a real step forward. Now, whether or not that would include individual penalties for particular government actors is another question. But nonetheless, once you take those first two steps, you've got a long way toward addressing the jawboning issue.
Look, I think maybe we should wrap up unless anyone has a few quick seconds of points you want to make. I will save my question for the next minutes like this, but I'll preview it for everyone, which is I am not entirely sure. I mean, I'm just an antitrust lawyer. Not entirely sure why some of this is in or affecting commerce, and I'm a little bit confused as to why there's Sherman Act or FTC Act jurisdiction. But as I said last time,
Thank you all for coming. We'll follow with more events on this topic. Thank you to Georgetown for hosting us, Professor Chunder, Renee DiResta, that are our partners here today. So we'll look forward to doing more events on this. This topic is not going to go away. And thank you to all our panelists for coming. But please stop. There's coffee and food if you'd like to take some more.
The cobbler's excellent.
Peachy even.
Peachy.